All right, for all you aspiring barristers gearing up for the Queensland bar exam, listen up. We all know that getting a grip on the rules of evidence isn't just a good idea, it's absolutely essential. So, this explainer is going to be your practical guide through the key parts of Chapter 11 of the UCPR. We're going to break down the rules you have to know, not just to pass the exam, but to actually build a solid case when you're out there in the real world. Okay, so here's our game plan. We're going to start with the single most foundational choice that shapes everything else. Then we'll get into the real power tools, like subpoenas, before tackling the tricky world of expert evidence. After that, we'll nail down affidavits, and finally, we'll see how to put all these tools together. First up, let's talk about the bedrock, Rule 390. I want you to think of this rule as the very first strategic decision you have to make. Honestly, getting this right from the get-go determines the entire road you're going to travel in presenting your evidence. And it all boils down to this one simple question. How did this whole thing start? Was the proceeding kicked off with a claim, or was it started by an application? Seriously, your answer to that question changes everything that comes next. And there it is, the core of Rule 390 laid out plain and simple. It's a fork in the road. A claim means your default is oral evidence, people in the witness box telling their story. An application, on the other hand, means you're working with written evidence by affidavit. Burning this distinction into your brain is step number one. All right, next up in our toolkit is a real game changer. So what happens when the document or the testimony you desperately need is with someone who isn't actually part of the case? Well, that's when you reach for Part 4 of the UCPR and the power of the subpoena. For your bar exam, you can't just know what a subpoena is. You have to know its entire life cycle. Think of it as a four-step process. First, you issue it, making sure you use the right form. Second, you serve it properly. Third, the person who gets it has to comply. And fourth, remember this, you, the party who issued it, you're on the hook for their reasonable costs. Now let's zoom in on a detail that trips up so many people, conduct money, which is all laid out in Rule 419. This is not just a nice thing to do, it's a hard and fast rule. If you serve that subpoena but you don't hand over enough cash to cover their reasonable travel expenses right then and there, the whole thing could be invalid. That is a classic exam question waiting to happen. Okay, let's roll up our sleeves and tackle one of the big ones, expert evidence. All covered in Part 5. This is, without a doubt, one of the most technical and critical areas you'll face, mainly because these rules completely revolutionized the role of an expert in court. To really get these rules, you've got to understand the problem they were created to fix. You see, the courts were getting pretty fed up with this battle of the experts. You'd have each side bringing in their hired gun who would write a report that was basically just another piece of advocacy. It was often muddying the waters instead of finding the truth. And that is precisely why Rule 423 and the rest of Part 5 completely changed the game. The whole point of an expert now is to genuinely help the court figure things out, not just to be another voice arguing for one side. Now, if there is one rule from this whole section that you need to know backwards and forwards for your exam, it is Rule 429F. An expert's number one overriding duty is to the court. That duty trumps any obligation they have to you, to the solicitor, or to the client who's footing the bill. Their evidence has to be impartial, it has to be within their wheelhouse, and they have to be totally transparent about what it's based on. This is a non-negotiable part of modern litigation. Okay, let's move on to affidavits, which you'll find in Part 7. Remember, if you started with an application, affidavits are your bread and butter. This is how you get your evidence in front of the judge. So getting the form and the content absolutely right is a day one skill for any barrister. Your starting point is Rule 430, subsection 1. And believe me, it is strict. For a final hearing, the rule is simple. If the person couldn't say it in the witness box, they can't put it in their affidavit. We're talking no hearsay, no personal opinions, no guesswork, just the facts, just direct evidence. But, and this is a huge but that you will almost certainly see on an exam, there is a critical exception. Subsection 2 creates a special carve-out for interlocutory hearings, the ones that aren't final. In that context, a person can include statements based on information and belief, but, and this is the kicker, they must say exactly where they got the information and why they believe it. Knowing when to use this exception is absolutely key. Look, getting the content of an affidavit right is half the battle, but the technical stuff, the formalities, those are completely non-negotiable. Rules 431, 432, and 435 lay out the mandatory checklist. It's got to be in the right form, it has to be sworn properly, and any exhibits must be marked correctly. A mistake here isn't just a minor slip-up. It can get your crucial evidence thrown right out of court. So, we've looked at all the individual tools in the box. But let's be honest, a great barrister doesn't just know what a hammer is. They know when and how to use it with a chisel and a saw to build something. It's about using these rules together, strategically. So let's tie it all together now. I want you to stop seeing Chapter 11 as just a list of rules to memorize. Instead, see it as your strategic toolkit. You start with that foundational choice under Rule 390. You use your power tool, the subpoena, to reach out and grab what you need. You wield the specialist's scalpel of expert evidence with real precision, and you build your case with rock-solid, perfectly drafted affidavits. So, as you're hitting the books for your exams and thinking about your future at the bar, I want you to remember this. Knowing the rules we've just covered, well, that's just the price of admission. The real art, the thing that will make you a truly great advocate, is learning how to apply them strategically, ethically, and persuasively to fight for your client. Now go get 'em. Good luck.